Perfect. Thanks. Sales?
Sales.
You wear a lot of hats at the company you work for? Yeah, got it. Okay. So we have a pretty tight timeline today. They have another class happening in here. They're doing OSHA training. So I've set the presentation to take about an hour to do, so we have plenty of time for questions. I'm going to go through the presentation and I'll stop and then give you an opportunity. A lot of what we're going over, I try not to fill it with a whole lot of case law and things to kind of make it boring and fall asleep, because I've done that in some of these presentations, not myself presenting, but having to sit through them. But I did go through and pull together a lot of information that I think what you need to know being an employer here in Florida. So you'll find in the folder in front of you, there's handouts I printed so you can take notes. It's got the slide details. I made the fonts large enough so you can read the details on the slides. You'll also find everybody who attended today, we're providing you a certificate to give you a free drug-free workplace program. So you just have to get with us. It's not like a cookie cutter thing. They're customized for you. So there's a little bit of an interview process we go through to answer all the questions. So that's something you can fulfill after today. So and then my contact information is in there as well. You guys have follow-up questions and kicked out. And I apologize in advance, I have a cough. So I'm drinking some hot tea. If I start coughing, I have to stop for a minute. Forgive me. So I'll tell you guys a little bit about myself. My name's David Bell, as it says here on the slide. I'm a father of 6 kids, happily married. I'm the owner of USA Mobile Drug Testing National Franchise. We have franchisees in 20 states. I help support their businesses. We're a national company. We have 500 mobile units throughout the country that comes on site. Various companies from Fortune 100, Starbucks, all the way down to just small individual owner-operator truck drivers or independent contractors, subcontractors that need some sort of a program and need to be tested. I'm also certified to do drug testing as well as trained to do drug testing, breath alcohol as well as urine. I get out in the field and get my hands dirty, as they say, no pun intended, because it helps me be a better manager. It helps me understand the process and what the staff goes through, and it helps us make USA Mobile drug testing a little bit better than some of the places that there's a lot to look for in the process. So, written numerous articles, some in the Construction Executive online in regards to medical marijuana, but in general articles about how drugs impact the workplace. I didn't start out with like a passion to say, hey, I want to be a drug tester. I actually owned a printing and marketing company, and this was a client of mine, and kind of went into this industry. So I've seen the impacts of drugs in companies that I manage as well as my own. Individuals being hurt, lose hands in presses, dangerous stuff. Opiates and different drugs are very impactful. So I understand and have been at the other end of that. I've been at your end as an employer and had to deal with those challenges. So we're going to go through really 3 areas today. HR or an owner, what do you need to know about medical marijuana as it stands right now? How to avoid being sued, right? So some key steps to avoid being sued by an employee or potential employee. And then lastly, we'll touch on creating a corporate culture that can help you defend yourself in the event that you do get sued. Legal disclaimer, obviously, we're not lawyers. I'm here to present to you what I see and what we see as a company employers facing. From Colorado and Washington and states that the marijuana laws have been implemented for much longer than in Florida. We're seeing lots of things happen. We're seeing decisions that they have to make and things they have to go through. So I'm kind of presenting in the field what people are dealing with from that perspective. A couple of slides here, in general. So last year, someone did a study, 600 users within recreational marijuana state. 48% of those 600 said they've gone to work high. 39% of those said they do so at least once a week. So it's pretty common for a daily user who smokes marijuana to get up and have marijuana with their coffee, right? Smoke a joint. That's how I can say without telling you who, a family member of mine worked for me at one point and said, I use marijuana every day, and I'm normal when I'm high. So I'm not normal if I'm not high. And after working for me for several years, admitted that they can tell the difference when they don't consume during the day at work. So, again, having touched it. Rocky Mountain high intensity drug trafficking area, so it's a federal enforcement. I did some statistics here just recently. This is a 2018 report, so it's like very recent, within the last month. In Colorado, marijuana linked crashes have gone up by 35% since they legalized that within the last 2 years. So, a lot of people say, well, it's safer to be high and dry versus drinking alcohol. Statistically, it's just not the case. Well-known long-term fact, but 5 times more likely to file a workers' comp claim. So if you have a regular user, they're going to tend to have a higher rate of accidents. Currently, we have 31 states that have medical marijuana laws. Only 9 of those states so far have any protection specifically for the employee, right? So many of the other states have some protections, like Florida for the employer. 9 states, a lot of them in New England, have case law to help support the employee's discrimination. But remember, no state, none, have any protection for any employees for termination if you as an employer stand to lose a benefit or license or any funding whatsoever. So there's really no protection from them if you can show hardship. So just a couple of facts to consider. So I wrote the Florida statutes down in case you want to look them up. They're not really long to read, but they're here for you. The Compassionate Medical Cannabis Act, it took effect here January the 1st, 2015. The Amendment 2, which is AKA the Medical Marijuana Legislative Initiative, was again voted on in 2016 in November. And then it was voted 71.25% into effect January 2017. It amends the Florida Constitution Article X, Section 29, that specifically is for individuals with debilitating medical conditions as determined by a licensed state physician to use medical marijuana. So that's what it's amending. Many of you might have known this already since it's become legal. You've probably seen what qualifies. Really what comes up and is disturbing for me is the way they use the terminology for other debilitating medical condition. I was in dermatologist's office the other day with my 5-year-old son. He has a rash that happens with kids. On the wall in the waiting room, they've got the medical marijuana program. Can imagine what people use for excuses to get a medical marijuana card. So the Senate Bill 8A was signed by the governor in June of 2017. This was something that we were really needing after the passing of the original law, because there was a lot of questions, things that didn't get answered with the law, which often happens, right? When there's some law that comes in, there's a lot of other things that come with it, and leaves a lot of challenges for people to, what can I and can I do? So there is no clarity, by the way. It failed to define or provide any greater specificity on the phrase other debilitating conditions. So it did not help you there from that perspective. It also failed to limit the maximum concentration of what is allowed, legally in your system. So pot can have any level of concentration in it. There's no maximum. So you're going to expect to see some very high concentration marijuana. One of the most interesting parts, and still haven't quite connected the dots, is the new laws explicitly prohibits the administration of medical marijuana by smoking. So again, don't quite understand, obviously it sounds like they're trying to just stop the everyday user who's just trying to skirt his way around the law, get some protection to smoke pot. But it does provide, legislature allows for possession of the flower, right? And they're saying for vaping only. And knowing what I know about how they convert leaf into an oil-based product for vaping, it's very dangerous. A lot of chemicals involved in some explosive chemicals, so it's kind of a challenge. It did directly address several employment issues, which is most of the questions that people have. It didn't define what an employer constitutes, right? They use the word employer, but they didn't say, hey, this is what makes you an employer. So I know many of you guys may work with subcontractors, 1099 employees. So are you an employer or not? That's not being covered in the language here. But it does expressly denies the creation of, and I'm going to quote, a cause of action against an employer for wrongful discharge or discrimination. So basically there's some protection in the legislation that allows you as an employer to fully enforce your drug-free workplace program without retribution. Now, is that open to debate and potentially going to have some lawsuits? I guarantee it. It's happened in many states. The legislature went a step further by expressly stating that employers are not required to accommodate an employee's use of medical marijuana at work. So there's language in there that says, if you're going to hire somebody in an office capacity, in construction, most of you are dealing with safety sensitive. Everybody on the job site, even if they're just carrying the tools from the truck and they're a helper, they're in a safety sensitive position. So you guys are kind of positioned in a uniquely category, but when it comes to accommodations, when you're office staff, different conversation entirely for you. Additionally, the statutes expressly prohibits medical marijuana users from using medical marijuana at their place of employment without their employer's permission. So they're setting up the stage because a lot of the ADA and the things that we're going to go over, they're looking to have you determine, is there the ability to allow somebody to work here that uses medical marijuana. So, but they can't do so without your permission, right? So some of the non-safety sensitive job functions. For employers that already have, and most of you probably already have, a drug-free workplace policy, 3D1.986, which is the statute provides, this section does not limit the ability of an employer to establish, continue, or enforce a drug-free workplace program or policy. The statute further provides that it does not allow reimbursement on your workers' compensation premiums. So for many of you, workers' comp rates are very high due to the nature. My father owned a cabinet business. I think we were paying around 15 or 18% in premiums. In Florida, you're receiving a 5% discount. If you're allowing medical marijuana in the company, any capacity, you could lose that discount. So you kind of keep that in mind. How does this impact you guys in the workplace? So the Article X, Section 29 of the Florida Constitution states, nothing in this section shall require any accommodation of any on-site medical use of marijuana in any correctional institution, detention facility, or place of education or employment, or smoking medical marijuana in public places. So in theory, even though they have a card, they're not allowed to be at a party, bar, outside of a restaurant, smoking pot. The amendment does not affect employers' rights to keep their workplaces drug and alcohol free. Employers who do not already have an existing drug testing policy are totally within their rights to build one that explicitly addresses employee marijuana use in the workplace in order to maintain employee performance, and these are important things to remember, safety and productivity. Because your argument as an employer from a hardship perspective is, in my case, when I'm hiring staff, administrators, phone, whatever they're doing for me, I'm paying for their undivided attention. I want them to be focused while they're at work. And productivity matters, right? Profit, bottom line. So having that language is pretty important. And for you guys, safety, as well as productivity, meeting quotas, is definitely things that you can use to fight the hardship. The ADA, Americans with Disabilities Act, most of you are pretty familiar with that, I'm assuming, being employers and HR professionals. So we'll kind of skip that for the sake of time. But there are 3 cases that I wanted to point out to you that have happened over the last about a year and a quarter. The first 2 cases here specifically dealing with pre-employment. Again, none of this in Florida yet. We don't have any cases, but I do expect to see some. In Rhode Island, Callahan versus Darlington Fabrics, the court in this case agreed that the company didn't hire the individual after giving them a job offer, specifically because they were a medical marijuana card holder. And so they let them fight that under the Rhode Island Civil Rights Act. We have a Florida Civil Rights Act, similar, alleging they were disabled, right? And so they didn't fight the medical marijuana, they fought, I'm disabled. So the lawyers are really working hard at trying to circumvent the reasons why medical marijuana is important to some of those people in the country. July 2017 in Massachusetts, Barbudo versus Advantage Sales. The employer, again in this case, withdrew for a failed drug test, pre-employment drug test. In this case specifically, the court focused on the disability. The individual had Crohn's disease, and under the medical marijuana, Crohn's disease is a debilitating condition. The court compared lawful use of marijuana to any other prescription. So they didn't even fight the fact that marijuana was an illegal drug federally. They didn't support that argument, but they did focus on the fact that this is just a prescribed drug. So they just immediately went right to the fact that this was lawful use because it was prescribed by a physician. So those are just some of the challenges that we're going to face, right? Dealing with these types of discriminating situations. About a year ago, Knopfsinger versus SSC Operating Company, which is a nursing home rehabilitation center. So, they deal with drugs, obviously. The U.S. District Court of Connecticut ruled that the Federal Controlled Substance Act, the CSA, which you'll hear me reference a few times, does not preempt Connecticut's medical marijuana law. The violation in this particular case was anti-discrimination. They did grant summary judgment to the job applicant, but they did make mention that the law had not been reviewed by any significant higher courts, right? So they kind of left this little caveat in there that it doesn't. They didn't want to go out on a limb and say, hey, this is cement, right? So they did kind of leave a back door. Good thing to know though, that employee did not get granted attorney's fees, nor did he get granted any hardship or pain and suffering, right? They specifically gave him the award that they should have hired you, right? So the opportunity lost was what was decided there. So again, as I mentioned, the Controlled Substance Act, the CSA, is a federal law which states that the possession or use of any form of marijuana is prohibited, right? So federally, as you all know, it's still illegal to possess it. Now I know there's been they've been handling it with kid gloves, right? They've been stepping down and saying, look, we're not going to prosecute many states as well as at the federal level. Somebody who has a small amount of marijuana on it, maybe it's personal consumption, they're not arresting you, they're not prosecuting. So if that's a trend as to what's coming up, just kind of watch that. Again, I mentioned similar to the ADA from a federal level, Florida Civil Rights Act, the FCRA, protects those employees from discrimination here in Florida. However, because Florida's medical marijuana law, right, the bill that was just done, expressly states that employers have no requirement to accommodate medical marijuana use for disabled employees while at work, and expressly prohibits the creation of a cause of action for wrongful discharge or discrimination. Employers deciding not to accommodate on-site use of medical marijuana should have little to no fear from employees attempting to bring suit against them under the ADA and the FRCA. So that's good news for you, right? For now, you hold a meeting with your employees, make sure that they get an opportunity to ask questions. There's lots of details you'll find as we do the interview for your policy that most people don't think about, and it causes problems with those employees that go through the testing side of it, that they're like, hey, I didn't know that was a refusal to test, and that's a positive, I'm no longer employed here. So make sure that they have an opportunity to get the policy, read it. The policies aren't 80 pages, they're like 15, okay? They're pretty easy to read. It's not crazy, but it's enough to cover you where it matters. Reasonable suspicion testing, again, every one of our clients, we offer free supervisor training to the supervisors that work at a company. We host a virtual online event every quarter so that those supervisors can get an interactive, kind of like what we're doing today, just virtually through the computer. We're able to tell if they're on the screen, they're in attendance, and they get trained on the signs and symptoms, as well as they get some really great handouts to use for just real simple documentation, because reasonable suspicions about what you see, what you smell, what you hear. And so on our checklist, it basically says, they were staggering. And then, their breath smelled. It lets them check off the things, so it's easy. They don't have to think about how to write it. It's really simple to help them document reasonable suspicion. You may even consider for you guys with construction, as we face more challenges with medical marijuana, adding into the policy, which we don't currently do unless it's specifically requested, drug-free job site policy. So in Illinois, under their law, many of those employers are adding specific language about a drug-free job site, which is helping them combat some of the challenges with the medical marijuana. You may know this already, but as you go to announce your updated policy or policy changes, if maybe you just updated your policy, but I don't know if you made formal announcements and meetings, but sometimes if somebody's using marijuana and you're now addressing marijuana specifically, you can't terminate somebody who says, you know what, I like my job and my career path, I want to get some help, right? So you got to let them get help, and then you got to put them back in the same position if they do complete the program. Some of the things that you can do, obviously, the DOT has been mandating this for a long time. They will have to drug test, talk to the substance abuse professional that they're going to go see, and make sure that you want follow-up testing, which they pretty standard apply. Maybe they've got to get 6 tests over 12 months, or if they're an habitual offender that they find out in the process, maybe it's 60 tests in 60 months, right? So in some of those cases, that's the way to go. I know in many of the policies too, it's very common these days, second chance, right? Somebody makes a mistake, somebody fails a drug test, they have the ability to get help, get healed, and get back to work. So that's kind of how that applies. And then I kind of alluded to it about educating your employees, but it's pretty important. What if they leave a testing site, right? They show up to get a drug test, or the tester like us, we come out and we're there and they decide to leave. We see it, and we show up at a port and they're like, the drug testing company's here, and you see people leaving, and they're like, hey, we're just not going to be here when the testing happens. Or a lot of our, early on in our company, we branded the vehicles, and we're showing up, and employers are like, come in an unmarked vehicle, because you pull up in the parking lot, and the guy smoking on the dock in the back has told everybody in the building the drug tester's here, and 6 people are going home, my kid's sick, I got to get him from school. It doesn't mean that they're selected in the random test, but it causes challenges, and we see it all the time. I mean, we see it, we walk in, we're doing a hire day at a Fortune 100 company in Georgia, and they were, they had like 30 applicants. They were going to get screened. When they got to like, okay, here, we're going to go over here and do the drug test. Actually, not again if they have a medical condition, but maybe choose to get help. They have an alcohol issue, they feel like it's impeding their job, and get back to work. We all oftentimes work with people we know, like, love, family, let's have them continue to work. So some of the things that those employees need to know specifically in regards to what happens to a refusal to test. So if I start a drug test for an employee, once I've taken their ID and we get started, they decide to leave, that's a refusal to test. So if you told them in a random situation to go, or they showed up for a pre-employment, once I have that ID, they've started the drug test. If they walk out under the policies that we write and under all the federal policies, it's a refusal to test, it's treated as a positive, you don't hire them. So a lot of people don't know that. They think they're playing games. You tell them, hey, you got to go to your random test, and all right, I'm gonna go right now, and you see them at 1 o'clock in the afternoon. They're like, I got busy and I couldn't go. Well, that's a refusal to test. There's no excuse. Your supervisors will get trained to know that when I notify you, you've got to go now, or we're there and we're testing now. So if they don't provide a specimen, sometimes they're required to take a second test if they don't do that as directed. One that a lot of people that don't deal with DOT know, if they don't provide a sufficient sample, we keep them there for 3 hours, up to 3 hours. On a clock, we give them water, ask them not to dilute the specimen, but to help provide sufficient evidence that they should be able to urinate within 3 hours. And if they can't, and they're unwilling to, by your direction of the policy, go seek medical counsel to say, hey, this person has a condition, they're unable to urinate potentially within 3 hours, which is rare, but it happens, which is that's why we follow that. If they choose not to go, it's a refusal to test, you treat it as a positive. So a lot of employees who are kind of just like, hey, whatever, they don't realize the severity of the actions they take even in that testing process could impact them just like they failed the test. So educating them is crucial to stopping the nonsense. So anyways, we'll go to the next slide. Lastly, here, testing, right? So testing has to be consistent. If you choose not to randomly test, fine, no issue. But if you're pre-employment testing and you're just a small company, you got 15 guys, you're a roofer, whatever you do, you need to make sure you test if you say you do. I can tell you from DOT regulated companies to maintenance crews, to the wide array of companies that call us. Do you have a policy? Yep, we got one, but we haven't tested in like a year. We haven't tested in a couple of years. We've just been really busy. And that's gonna screw you more times than I can lead. Post-accident testing, which you were talking about, you have to test consistently. We deal with one trucking company, they go above and beyond. They probably, in one of our stations in one of our cities, we probably test 3 to 4 times a week. Somebody scratches the truck, even though that's not a DOT test, you're getting a drug test. Because they just know nonsense. They don't want to deal with the liability. They're self-insured. They'd rather spend the money on the drug test than deal with the liability of killing somebody because the guy's using drugs. So that's the way they handle it. Reasonable suspicion testing, again, a lot more than I'd like to admit. We get phone calls from somebody who says, we want you to come randomly drug test 10 people, but I'm going to give you the names. I want these 3 guys to be in that list. And I'm like, look, if it quacks like a duck, right? It's a duck. So if you have reasonable suspicion that John over here is using drugs, just write up the paperwork that we provide and say, I'm testing you because we think you're using drugs. Most of those supervisors that are friends don't want to be the one that had called them out. But that's part of being a supervisor. You're making more money. You're there to represent the company you work for, right? So that happens a lot. Return to duty and follow-up testing, and then really, as an HR professional or the supervisors, know what type of test and why, right? That's really important. Be consistent 100% of the time about your policy. Again, as you brought up, no exceptions. The exceptions are going to be a challenge. Don't let your supervisor, unbeknownst to you as an owner, have this kind of unwritten policy that it's okay, to get high or maybe drink on Friday after payday. I hear lots of stories. One of the services that we provide is a telephonic nurse triage. So it mitigates your risk as an employer, and all that really is doing is basically trying to mitigate your cost for workers' comp. So there's a fender bender. Well, they're recording the call. They're documenting everybody in the truck. How do you feel? Everything's fine. You know, and the next day they're all in the ER and everything hurts. And you know, so they use that to try to mitigate the cost for insurance fraud. But a lot of times you find that the guy driving the truck, the supervisor, and they're smoking pot in the back. And he's not, but it's happening, right? So that can, in a legal perspective, lawyers in the room, no. From a legal perspective, the absence of him taking actions for your policy is a new policy, potentially. He's circumventing your policy and just basically creating one that you could be liable for because he's not taking actions. So it's very critical that you monitor that. Confidentiality, so the test must be confidential, the results. If you're identifying somebody who has, maybe their appearance is deteriorating, they're late to work, their performance is hurting, maybe they got an alcohol issue, maybe it's drugs, you know, maybe somebody died in their family and it really hit them hard, but you notice this deterioration, but it isn't the type of reasonable suspicion that's like, hey, this guy's walking, you know, he's just come back from the pub. You don't want to go up to that guy in the middle of a job site and have the conversation. You need to, in those events, you need to make sure you get in a private area to have a conversation and say, hey, we have some concern, performance. There's usually meetings. All that paperwork's provided to your supervisors in our training, but needs to be confidential. And then what I don't think most people recognize is that in your record keeping for your drug tests, even with it's now a lot more digital, drug testing results, while none of the drug testing for workplace is governed by HIPAA, it's not health related whatsoever. We're not governed by HIPAA, but the drug testing result is more confidential than that employee's file. So if you've got 10 supervisors that work in the company and you're in HR, and any of them can come into the HR office and grab, you know, Mary's folder out to get information or add information, drug testing results should not be in there. They need to be kept in a secure, different place. It's not to be public knowledge. The federal program, as well as DOT, talks really highly of that. So confidentiality is really important. It's really neat to know. A few tips for supervisors. They're in your handouts. Again, it just kind of points out some of the things that we just talked about. Just kind of bullet it, so you can maybe print that slide out and hand it to them. And then again, another resource for you, findtreatment.samhsa.gov will help you find a local employee assistance, SAP, maybe in the area where you need help, or maybe you have remote employees working in another area and they're not local to you. We also provide an additional referral service in our policies. Any questions so far? I know I'm going to cover a couple of things that you guys had asked for still in the next couple of sections. We've got about 5 more minutes probably. No? All right. So corporate culture matters, right? From the top down, what does the owner of the company say that they're going to do within their company from a policy perspective? Have an open line of communication. So everybody should speak the same way, talk the same way about the policy. It's zero tolerance, it's zero tolerance. If we're going to make accommodations in our non-safety sensitive functions, then you're going to make accommodations, and this is exactly how those accommodations work, and that's the way the company goes. Be sure to state why or why not that you're mandating zero tolerance. Some of the things that I'm going to show you here in a minute will help support you as into why not currently. But if you're in support of it, just be careful that your support doesn't overstep maybe your zero tolerance, but as an owner, maybe you don't really have that big of a decision one way or the other. Your beliefs don't necessarily mean policy, but the lack of action against your policy can become policy. You guys probably heard earlier this year about AutoNation. AutoNation, 26,000 employees, largest auto chain. 2 years ago, the CEO changed the policy that they'll allow everybody to come to work. They don't screen for marijuana. He did it silently. They didn't really promote it, but obviously through the marijuana pro-advocacy sites, about January of this year, it was all over the news about AutoNation, if you're high, you come to work. So, and that's not really, that's the media playing on it, but they changed the policy trying to get in line. They're a Florida-based employer with nationwide locations. So it's becoming more widely known. And again, in that same case, as we're talking about owners, many people have used that there's too much oversight, and it can impede our privacy. And the things that your employees are doing on their time is their time. But as an employer in a safety-sensitive situation like construction, the safety is the concern, right? Your guys that are serious about being safe and going home and keeping their fingers and to support their kids, they care. So by being an employer that supports zero tolerance, you're really supporting that culture for them to know that you're on their side, even if that's a difficult situation for hiring new people. So as an employer, even if you do adopt and allow some off-site medical or recreational marijuana, as it's going to become potentially legal here, here's why you maybe shouldn't. So first off, out of everything I've said about the marijuana laws, there's zero clarity without 100% certainty that you can fire somebody or what's going to happen if there's a major accident. So if you adopt laws right now, or your policy is that we're going to allow off-site consumption, we're not going to discriminate against THC in your system, it's going to impact your ability to fight major accidents. We're hired by some major carriers, and we go collect blood samples after accidents, even from cadavers, to try to detect the levels and quantitate what's in the blood to determine impairment. So under the Federal Drug-Free Workplace Act, if you're federally governed, you got federal contracts, federal funding, certain loans, you should be protected from any liability of terminating an employee for consuming medical marijuana due to the preemptive nature of the CSA. As I mentioned in the Carlson versus Charter Communications, that court found that CSA did preempt in that case. Now, Florida's Drug-Free Workplace Act, there's really no clarity. There's been really no litigation on it yet. It's still very new. Not anything definitive to bring out today, but it does expressively provide you the ability to not limit how you implement your drug-free workplace program. So it says that. So you have some security to know that you can take actions in Florida and uphold your random drug testing policy, and if they fail the drug test, medical marijuana card or otherwise, that you can enforce your policy. I think I may have mentioned earlier about prescription, right? The word prescription is not defined within the Medical Marijuana Act, but here in the Drug-Free Workplace Act, it defines a prescription as any other ordered drug written or transmitted by a licensed practitioner, where the medical review officer is reviewing that positive drug test to determine if there's a prescription to overrule it. But currently, marijuana is not considered a prescription. That could change because of the marijuana law. It's not. But with the way our law is written currently, it does not limit the employer's right to enforce its drug-free workplace policy. So your takeaway today should really be, you're good with zero tolerance for now in the Florida, okay? To cover your guys' questions specifically, technology, right? The actual testing that we're using to detect impairment in marijuana doesn't exist. Doesn't exist. It's inadequate. There's nothing on the horizon. There's nothing that, and I'm in the industry, I wrote an article last month about breathalyzer for pot. California Highway Patrol's consider, they're taking a back seat. They don't want to try it out, but Colorado, some of the smaller police agencies are willing to try the device out. The problem is it's trillions of parts within the lung for THC versus thousands of parts for alcohol. So that's why almost every one of our companies that we work for, we do a breath alcohol test with a drug test to determine impairment from alcohol. for non-DOT and DOT alike, for post-accident reasonable suspicion, right? And randoms, we do a percentage of alcohol testing for those guys in a random situation, especially in your industry, because alcohol is pretty prevalent, especially on lunchtime, weekends, when guys are working late nights, they're drinking. So showing up and doing an alcohol test could stop that, potentially. But again, if you have in the Florida Drug-Free Workplace program that they currently have, it's all urine-based drug testing. So it's looking back to 4 hours or so, up to a couple of weeks, and maybe longer depending on a daily heavy user. Oral fluid testing, which you see like Home Depot, Lowe's, some of those companies are using that type of testing. It's really just giving you a window of about 2 hours to about 24 to maybe 36 hours. So in the world of arguing, is somebody consuming marijuana and that caused this accident, at least it's a smaller window, right? I'm not saying, hey, they could have smoked it last 2 weeks ago and it's showing up today. So that could narrow the window and help your argument, but it still doesn't detect impairment. It will show you the level of nanograms potentially within the specimen, so will the urine. And there's still a lot of haze, and there's still, pun intended, there's still a lot of haze as to how that works, right? The impairment in Washington was set at like 5 nanograms, which 5 nanograms lingers for a long time for somebody who smokes pot every day. But that doesn't mean that they're necessarily impaired enough to not drive. But that's where that's where there's a set at. And again, even though that breath alcohol test is kind of out there, it doesn't detect impairment. It just detects currently whether somebody has smoked pot in their lungs. So if they've eaten a brownie, it's not detecting that. It's only detecting whether the marijuana was in the lungs within the last couple of hours. So they're not a smoker, but they're using oil or they're using some other product, it's not detecting it. So that's specifically why allowing marijuana on your policy, or generally, hey, I don't care what you do on the weekends, you can't say that as an employer. You might believe that, but you can't say it because what they do on Sunday night could impact them on Monday. But think about it. If you guys have a flight at 8 a.m. on Monday morning and your pilot was high all weekend long and comes to work and he's got to fly your plane at 8 o'clock in the morning, you think he's good? I don't want to take that chance. Although he could be drinking, but again, he has to be outside of that time frame before he flies. Workers' compensation for anybody here self-insured? Yeah, it's pretty rare. Accommodations self-insured, 26,000 employees. So their ability to basically say, we're going to exclude marijuana is because they're self-insured. They just deal with case-by-case situation and they mitigate their risk case by case. It's cheaper for them than paying premiums to an insurance company. So they're able to make those decisions. Everybody here, and for smaller employers, you're dealing with a workers' comp carrier who has an underwriter who's looking out for the rights of that employer. You can't exclude it. I'll give you an example real quick. We have an employer that grow marijuana from Nevada, 100 employees, growing. They're going to have like 200 employees in the next 6 months. And they don't want to be hypocrites, they allow consumption of marijuana in their policy. But they don't, test for it. They just omit that in their testing for pre-employment, and the guys come to work. But they're somewhat safety sensitive. There's forklifts, there's things they're dealing with that are safety sensitive. Not all of them, but some. I mean, this was recent, right? This was like 3 weeks ago. So they're consulting with us to try to figure out their workers' comp carrier is still writing their insurance only because of the language that they say, if we do post-accident and reasonable suspicion testing here. They don't do randoms, but if you have an accident or we think you're impaired, and if you have pot in your system, workers' comp isn't going to cover you. So they're writing it only on the case that they don't have to pay the bill. So that employee has to be educated. Now, how that's going to impact them legally, I can't answer that. When they have a serious accident, forklift driver crushes somebody, one of my franchisees in New York, a guy backed into him in a forklift when he was in his 20s, in a warehouse. crushed his rib cage. It happens. You just don't know somebody's impaired. So they haven't had an incident yet, but it could happen. So for all of you guys that have workers' comp insurance and general liability insurance, and you have underwriters, and even if they're small companies, they're not sophisticated enough currently to say, hey, if you're going to allow marijuana here, we're still going to write your premium, and this is how much it's going to cost you extra. They just don't have a way to gauge it, so they're just straying away from it.
But does the employee have the potential to say, well, I have a medical marijuana card and I wasn't smoking during the accident or anytime near the accident, so I should be covered?
Can't prove it. We can't prove it. The workers' comp carriers, I mentioned, they call us to come get specimens from blood. They use the blood because they're saying that in the blood they're able to detect the level of it, and they can kind of argue from a medical perspective whether this person would have been impaired based upon the level of narcotic, whatever it is in the system. So that's why they use the blood. It's not very cost effective for just general employment. It's a couple $100 to get the blood analyzed versus like a urine or oral saliva test. So no, they can't prove definitively that they didn't consume, and we can't prove that they did, one way or the other. So there's insufficient technology. So you really, as an employer, have to state zero tolerance right now until enough laws change. In closing, I would say that the section 381.986 has provided a lot of guidance for you guys employers. Ultimately, unless the CSA changes how they look at marijuana at a federal level, which they may or may not, it's pretty clear that you have plenty of protection here in Florida to enforce your drug-free workplace policy, zero tolerance. So, again, always consult a lawyer. No matter whether they write the policy or they don't write the policy for you, they're always happy to defend you at whatever the cost. I know I've had some of those myself. So, hopefully this information was helpful. Any questions that you guys have that we didn't clear up for you? All right, you guys are still awake, so that's a plus. All right, appreciate your attention today. Anybody at your work, supervisors that couldn't make it, we're going to